day, my name is Mark Malore. I'm here with the Malore Law Firm, and we're talking today about mechanics lien rights for contractors and subcontractors that aren't getting paid for the work they're doing on a project. Now, many times my contractor clients come into my office without the understanding, believe it or not, of what they're supposed to do to perfect their mechanics lien rights. And sometimes I find that very hard to believe, because it's important to know when you can and when you can't file a mechanics lien and how exactly you go about perfecting it. The reason why that's important is the mechanics lien is the first line of defense, or first line of offense, if you will, for recovering money you're owed on a project. If that's not done properly, you waive that right, and that's probably the easiest way I have, or somebody like me, an attorney of your choosing perhaps, has to recover money for you on a project. Now, what am I talking about? If you're a contractor contracting directly with the owner, you don't need to file what's called a 20-day preliminary notice. The 20-day preliminary notice is what's needed to be sent by certified mail, return receipt requested, to the owner of the project, the lender on the project, and the general contractor on the project, if you're a subcontractor, to notify all three that you are a subcontractor working for that project and doing work. It notifies all three individuals. You need to keep the certified mail return receipt request postcards that come back to you in the mail. You need to keep those with your 20-day preliminary notice. You need to have the correct addresses on your 20-day preliminary notice when you send that out. You need to keep those in your file for further use should you be required to record a mechanics lien against the project and the project owner. Now, assuming you've done that correctly, the 20-day preliminary notice covers 20 days prior the work that you've done or materials you supplied to the project, whether you're a material man or a contractor, subcontractor. As long as that covers the 20 days prior, and as long as you file that within 20 days of first appearing on the project, it will cover all of your contract price and anything you've done. The later you record that, or later you send that out rather by certified mail return receipt requested, the later it is and the less you technically have the ability to recover in a subsequent mechanics lien case. You want to make sure you file the 20-day preliminary notice if you are a subcontractor on a project. If you're contracting directly with the owner, it obviates the need for the 20-day preliminary notice, but then you need to look at your mechanics lien rights on the project. And that's the next topic we'll talk about. Today we've talked about your requirement to file the 20-day preliminary notice, and hopefully that was helpful with you. If you need any other information or further advice, I would contact the website that we have, www.malorelawfirm.com, or contact me directly and set up an appointment, or with your own counsel nearby at the number below. Thank you so much.